Welcome back to Eyewitness News. Our legal counsel, Charlie O'Hara, here in the studio once again. If you have a question, 436-1212 is the number to dial. And good morning, Charlie.
Good morning.
Always glad to have you here in the studio.
Nice to be here.
We've got some phone calls on the line already for you, some questions. We'll go ahead and get right to those. Good morning. What's your question for Charlie?
Good morning. I have a house that I was renting and was recently damaged in the tornado. And my landlord's telling me that I can move, but he's refusing to give me back my deposit. Can he legally do that?
Well, I have an opinion first, but I want to say initially, but I want to say something first. Almost every time you rent something or buy something, it's always governed by the contract that you have with the people. I would assume in most contracts, a force of nature like a tornado negates that contract. In other words, you can't live in the house because the tornado tore it down. And he can't rent it to you because the tornado tore it down, so you both should just part ways and be done. As far as the deposit, I would think he has to give that back to you. It's not your fault that the tornado hit the house, and you put the deposit up, so everybody should just be out of the contract and you should get your money back.
And when we're talking deposits, most of the time we're talking about if a dog messes up the carpet or something like that, something that you've done or someone that you know has done something.
Yeah, some negligence on your own behalf, but that's an act of nature, an act of God that they brought in, the tornado came in, so it's not her fault. She should get her money back.
So read the fine print on that contract. And
I'd read that, but I think that may even actually come over that. I mean, that's pretty standard in the law, that if some natural disaster happens, that everybody's just out of it, where they came in and it's over with and they go on about their lives.
Okay, thank you, Charlie. Good advice. All right, we're going to head back to the phones. Another phone call on the line. What's your question for Charlie this morning?
Yes, I was at, hello?
Hi there, we're here.
Okay. I was at a casino, and I'm disabled, and I wasn't walking quick enough, and security was escorting me out, and I was cuffed and cut my wrist. They broke my finger, but I was charged with criminal trespassing, and I settled with the, Did
you enter a plea of guilty then to the trespass?
Yeah, so I wouldn't have to do jail time. I paid the fine, and now I'm finding out I have no, nothing to...
a lawsuit against the casino? Well, probably. Usually when something like that happens, if a criminal charge is filed and you plead guilty to it, it does take away a lot of the impact of a lawsuit about somebody with excessive force. I think it must be what you're asking about. The excessive force is actually sometimes rather hard to prove. I mean, reasonable force under the circumstances is looked at kind of an objective standard, and the fact that something happened to you, if you were raising Cain or not easy to get along with or something like that, they can escort you out of there. So probably you don't have much of a lawsuit, and especially when you plead guilty to a criminal charge surrounding that, it shows some bad conduct on your behalf, which probably helps in the conduct they have. Obviously, people can't beat people up because they're not cooperative, and they can't hurt people because they're not cooperative. We don't live in a society where we hurt people just because they're mouthing off or hurting people, but you usually have to take the whole thing as a totality of the circumstances, and probably he wouldn't have much of a lawsuit.
Okay, thank you, Charlie. Good to see you again.
Good seeing you.
And we'll see you in a few weeks.
Okay.